and we have some technical difficulties that we're trying to straighten out, and I'm hopeful that we will get there. In the meantime, you can enjoy a beautiful picture of Dr. Brown's daughter.
Okay, well, I don't know how to fix it, but just extend that.
Our presenters today are Dr. Alexander Brown and Attorney James Grogan. Dr. Brown is the Clinical Director of Metropolitan Family Services. He is responsible for clinical program development as well as for accreditation at MFS. Dr. Brown also maintains a private practice of psychotherapy and is a reviewer for the Council on Accreditation, an international accrediting organization. Mr. Grogan is the Deputy Administrator and Chief Counsel for the Attorney Registration and Disciplinary Commission. Everybody's familiar with that agency.
Can you get him to the main? Yeah.
He has investigated and prosecuted hundreds of charges of lawyer misconduct and has argued dozens of disciplinary cases in the Supreme Court. And he is an adjunct professor at Loyola University of Chicago School of Law, where he has taught legal ethics for 19 years. I'll let Mr. Grogan speak first, and then hopefully by then it looks like our technical difficulties are worked out. So maybe not quite. Okay, so James Grogan will speak first, and then Dr. Brown.
And I'll lead off, and unfortunately I won't wander around the front of the room because the technical people have to take care of that. But thank you so much for allowing us the opportunity to come out and spend a couple minutes. And I also want to say that after the conclusion of the program, if you have any questions, I'll remain after. If you have a hypothetical associate or a hypothetical supervisor you'd like to discuss, I'm more than happy to help you with that. This topic of difficult clients, let me tell you that at the ARDC, and just to show hands, how many people are non-lawyers? How many people are healthy and happy? Good. That's very good. Just a little bit of background. I work for an agency of the Illinois Supreme Court. It is an agency that the lawyers know regulates the practice. The Illinois Supreme Court licenses lawyers in this state, and we are the Supreme Court agency that fields grievances or complaints against lawyers, and if necessary, prosecutes charges of professional misconduct. All lawyers in the state are governed by an ethics code that has been in existence since 1990. And unfortunately, the existing ethics code is a little bit antiquated. And unfortunately for the practitioner in this field of endeavor, pretty much the ethics code is impossible. It offers you minimal practical guidance in dealing with clients who may be difficult. Now, let me tell you that we have two audiences at the ARDC. We have an audience of complainants, if you will, because people are very active in filing grievances. On an annual basis for the last several years, we get no less than 5,900 complaints per year against Illinois lawyers. And for the last couple of years, we have fielded 6,000 complaints. That's fair to say. Now let me tell you what we in the lawyer regulation world are absolutely panic-stricken about. Panic-stricken. There have been 4 recessions, and I'm using the historical definition of a recession, since 1973. The deepest recession in terms of job loss and concerns for most members of the public was 81 through 82. This one promises to be as deep or far worse. As a result of that, lawyer disciplinarians are worried about the future, and here's why. A couple weeks ago, I went and looked at some statistics. The recession of 81 through 82 saw that the ARDC averaged over 2,000 investigations per year for each year of that recessionary period. We saw no increase in our investigative caseload during the period of hardship. But for each of the 3 years following, immediately after the recession, we saw our investigative caseload increase 43% each and every year. We are expecting that same worrisome trend this time. And why does that happen? A couple factors at play. For one, sometimes, and it's usually after the recession, clients discover that the lawyer has done something terribly wrong during the period of recession. The lawyer has had economic hardships, has taken money, has done something wrong, and it takes a while to figure that out. In addition, what we see in times of economic hardship, our lawyers will take clients. Now, I know that's a luxury for you, right? But lawyers will take clients that they shouldn't take, that in times of plenty they would stay away from, that they would be in a situation where they'd say, this guy has been to 7 lawyers for this matter, and I'm number 8, guess what? And that client uses buzzwords, horrible buzzwords, when they come in the office, like shyster, okay? You shouldn't take that client, right? Unless you know what you're headed for, unless, welcome to your industry. A lot of times you take them as you find them. In addition, we find lawyers tempted to do things like take certain cases that in a time of plenty they would say, I got a conflict, I can't take this. Or this is something we see, that in times of hardship, lawyers will decide amongst themselves, I'm going to take this case. I've never done an immigration case before, but heck, there's a lot of immigrants out there. I should be able to manage this. And it usually takes about a year or two to see the path of destruction. Now, I'm not saying lawyers can't come up to speed. There's a lot of good lawyers who can come up to speed, but there's a lot of people that can't come up to speed, and that's when it impacts on us. So we have a very big interest in difficult clients because, trust me, we deal with all lawyers' most difficult clients because they find their way to our doors. I went to Loyola Law School. I like to think it's like the class of 1933. It was a long time ago. Going to Loyola with me was a guy who was a couple of years older and obviously a couple of years more mature. A very nice man. And after we graduated from law school and got admitted to the bar, he wanted to get into private practice, and he was interested in litigation. And he was a small firm lawyer, and he enjoyed himself. And one day, I'm at work, and someone called me, a classmate, and said, did you hear what happened on LaSalle Street at the Marquette Building? I said, no. He said, Cy was murdered. I said, what happened? He was representing a litigant in a dispute. There were 2 brothers. The brothers were fighting over some commercial property. And he was deposing the brother on the other side of the litigation. The brother on the other side of the litigation fixed on him as being the cause of his own troubles. And he shot him dead during the course of the deposition. Whenever a judge is killed, whenever a family member of a judge is killed, whenever a lawyer is killed out there, you better believe that that person who has pulled the trigger has been to the disciplinary commission. Now, we've tried to deal with people. We will deal with people on a case-by-case basis. We deal with a lot of healthy people, but we deal with a lot of sick and tragic people. And sometimes sick and tragic people are those best victimized by people in a position to victimize them. So we have to handle each and every matter that comes to our attention in a professional way. So that's our first audience, the audience of people that come to our office. And interestingly enough, when we look at the type of people who are the subject of a grievance, and again, I said we get 6,000 grievances a year, it's going to be the criminal law practitioner, it's going to be the divorce lawyer, it's going to be the tort lawyer, it's going to be the real estate lawyer. People in your industry, negligible. And that speaks volumes about the amount of care, because you have no control over a lot of the people you deal with. And I ask you lawyers in this room, how many times have people said to you, I'm going to file a complaint against you? Okay. I'm going to file a grievance against you. We'll talk about that in a minute. Okay. Now let me talk to you about the other audience. As of Halloween, we're real perverse at the ARDC. We do our statistics finishing on Halloween. As of Halloween, we had in excess of 85,700 lawyers on the master roll of attorneys. That does not include the miracle of a week ago Thursday when 2,400 new lawyers were admitted to practice. So we've got far in excess of 87,000, lawyers in the state of Illinois. And what I like to say is that's our second audience. Well, we deal not only with difficult clients, we deal with difficult practitioners. In a community of 88,000 human beings, we have no less than 8,800 practicing alcoholics. That doesn't include the drug-addicted lawyers. That doesn't include the behaviorally challenged practitioners. That doesn't include, and we are seeing a really worrisome trend of Alzheimer's and other issues relating to aging in lawyers in their 50s, which, trust me, hits home real hard. But we've had situations where lawyers are suffering from significant impairments, and it's a challenge for all of us in the future is how to deal with an aging practice base. The nice thing about lawyers is we can practice for a good long time. I like telling people that lawyers aren't surgeons. We lose our fine motor skills, so what? Doesn't matter. We can practice for a good long time as long as we remain healthy. Well, trust me, we see a lot of unhealthy practitioners out there. And it's a really nice challenge when you have a difficult client meets a difficult lawyer. You'd be surprised how often that happens. Because I bet sometimes you've had people come into your offices and say, I've been to lawyer A, and you go, oh no, I know what's coming next. And they relate to you a tale that you can believe. I've been a member of an organization a long time, and they try to do the paperless thing too. And we try doing novel things like putting things on a website. No one downloads the junk from the website. For the 3 of you who have, you can refer to the materials. For those of you who didn't, don't worry about it. But in those materials, if you'd like to check, we give you some statistics. And I give you what I say is a play in 4 acts, 4 different scenarios where the difficult client comes into a contact with the regulatory authority, and I'll tell you how lawyer regulators will handle matters. The first scenario is a case involving a young lawyer named Jill Gilbert. It's a Wisconsin disciplinary case. Now, more and more lawyers have dual licenses. This lawyer has a Wisconsin and an Illinois license. She was sanctioned in the state of Wisconsin. And whenever a lawyer is sanctioned when they have a dual license in another jurisdiction, will impose full faith and credit to that sister state's disciplinary order. And we'll do it fairly quickly. And it's a really kind of novel area of our practice, because if Wisconsin sanctions a lawyer for a certain act of misconduct and we don't have precedent in Illinois, oh well, because the Supreme Court will impose reciprocal discipline, that extends the precedent from Wisconsin into Illinois. It becomes Illinois law. So here's a young lawyer. Now this is what is interesting about this case. She comes to meet a client, and it is the archetypical difficult client. Not a man who has a guardian. He was in the military. He's a tough old bird. He hates humanity. He's had some difficult health issues, but he's never had to have a guardian appointed. But he's just a jerk. I don't know if is there a clinical? And it's getting progressively worse. And this is a guy in years in his Wisconsin community who had a good community lawyer who represented him through thick and thin. Finally, the lawyer said, look, God love you, but I'm not representing you anymore. You got to find a new lawyer. So he needed a new lawyer, and he found this young lady who was a practitioner in his community. And she signed a fee agreement with him whereby he agreed to pay her for any services she performed $125 per hour. Fair, not a lot. It's Wisconsin. So what happened thereafter was, within a period of 6 months, she charged him a total of $112,000 for legal services. And what's interesting about this case is the Wisconsin Supreme Court eventually heard from people in a nursing home where eventually he went because physically he became too debilitated. And the nurses got worried that this lawyer was always over there. And the nurses would say that she's over and she's giving him pop, or she's giving him something to drink, or she's giving him food, and she's always here. Well, she was charging her legal fee for everything. As a matter of fact, the Wisconsin Supreme Court said that she had charged him for essentially fetching services. And the Supreme Court basically said, this might not be a person that was without capacity to deal with you, but he was essentially a sick and troubled client. Now let's talk about the common law without even talking about rules. I told you earlier for the non-lawyers that there's an ethics code that governs lawyers. Great, but there's also a body of case law that all the lawyers know in the room that if our Illinois Supreme Court or one of our appellate courts says this is the way lawyers should act with clients, that becomes part of the law. It's called the common law. It's precedential. We have to follow it. So forever and a day in our state, the common law has been, when a lawyer represents a client, she owes a fiduciary duty. And a fiduciary duty, as you all know, it's like parent to child. It's like doctor to patient. It's like minister to the person in the congregation. It's lawyer to client. It's the highest duty imposed by law. You have to protect that client, and you can't abuse that relationship. Well, most clients, if I was to represent you as a lawyer with anyone in this room, we're pretty much on an equal plane. I have a fiduciary, I have to protect you. But if I'm dealing with the sick, the troubled, the challenged, common law says I owe a higher duty to represent you and protect you. And the sicker you are, the higher the duty. If I represent a 3-year-old child, sky-high duties. I represent a 100-year-old woman in a nursing home who doesn't have the requisite capacity to enter into estate planning. It's a sky-high responsibility. So the law says we have to protect them who can't protect themselves. And so the Wisconsin Supreme Court, and the Wisconsin Supreme Court looked at other things she did. Like what? Well, he had a widescreen TV in the nursing home. Don't ask me how, he must have brought it from home. And she saw that the widescreen TV wasn't working. So she went out and she had power of attorney and basically bought a $3,000 widescreen TV. And when the salesman, this is Wisconsin, he says, you know, this is a very nice TV, why are you getting it? Oh, because, you know, we try to turn the TV on and it doesn't work. He said, well, you know, I don't have to sell you the TV. I'll tell you what you should do first is I'll sell you the batteries for the remote. And you can try changing the batteries in the remote. You don't have to buy this TV. First, she said, no, I'll buy the TV anyway, and she took the TV. So that's a lawyer who deserves to be disciplined for taking personal advantage in a number of different ways of an impaired client. The second act I'd like to tell you about is an Ohio case involving a lawyer named Jeff Witt, who for all intents and purposes was, according to the Ohio Supreme Court, a real good lawyer, not a bad attorney. Here's what happened. He's a criminal defense lawyer. Woman comes into his office and says, look, I have an elderly mother. The elderly mother's in a nursing home, and I don't like those people in the nursing home. And I really want to aggressively protect my mom's interests. So he says, okay, well, I'm a criminal lawyer, but you know, I know a little bit about nursing homes and this, and I'll start representing you. And he charged her fees over the course of time. He asked for a retainer, basically he asked for $10,000, and he did an awful lot of work because it turned out that this woman he was dealing with, the daughter, was a difficult client. You know, the type of client that will call daily, the type of client who is most demanding, the type of client that wants to direct the lawyer's work. You do this, you do that, and you know, never a thank you, and just demand, 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 demand. And what invariably happened is she filed a grievance with the Ohio disciplinary authorities because he did something that she didn't like. So the disciplinary authority looked into it, and this is what I mean about inadvertent consequences. They looked into her claim. Like most regulators, they'll look at it carefully. They realize she's a difficult client. They look at the work performed by the lawyer. They say, the lawyer did nothing wrong. As a matter of fact, seemed to do a good job for the client. However, where did he put those retainers? He was disciplined for mismanaging the retainers. So sometimes a client can bring something to our attention that we say, we're not interested in that, you did a good job, but there's some practice issues that come about that we'll look at the practice issues and say, you screwed up over here. Third situation, and I can't tell you how often this happens. A Kansas case from 1999, David Druten. He's in a smaller Kansas town, and you could do a study on this. In high school, he had a football coach, and the coach was an aggressive coach. One of these ultimate, you know, you do it, tough love coaches. Well, this guy apparently benefited from his relationship with the coach. He goes away to college, he goes away to law school, he comes back to the town and he starts a practice. Well, one of the first clients that walks through the door is his coach, who has left coaching in high school to be in the carpet business. And apparently, with the psychological burdens of dealing with representing your high school coach, came the fact that as aggressive as he was as a younger coach in high school, he was an incredibly aggressive and belligerent client. And this kid was pretty well cowed by this coach. And the record shows that the coach turned over a number of collection cases to the lawyer to prosecute. Some of the cases were junk, some were viable, but this was a coach that was in his face all the time. You know, even though 15 years had passed, not a day had gone by. And the coach still looked down on this guy. Well, this guy was so cowed that he stopped doing work for the coach. But he kept telling the coach he was doing work. Kept telling him he was doing work. Kept telling him he was doing work. Because he was so frightened of delivering bad news or assertively saying to the coach, this is the fact situation, that he lied. And we see this a lot in lawyer regulation. Not really bad people, it's they're caught in unfortunate circumstances and they make some real bad choices. Final Tale is a case that I prosecuted years ago, and it shows how even though a lawyer may not personally take advantage of an injured or a disabled client, that not protecting the interests of the client can really be paramount. This is a lawyer who was a fabulously wealthy personal injury practitioner. There was a woman named Julia. Julia was driving down Roosevelt Road in the western suburbs. It's going back many years, in the 1970s. And when she proceeded through an intersection, an 18-wheeled truck came the opposite direction and crashed into her automobile. She was unconscious for a week. She suffered profound brain damage as a result of the accident. While she was unconscious, a Chicago lawyer named W.J. Maitan miraculously appeared at the victim's brother's house to offer his services. Now you say, ain't that ambulance chasing? I'll leave it to you to decide that. But he just appeared unannounced at the door. And he got the brother to sign a contract under the suggestion that he could help the sister if she ever recovered, because she had 4 little kids at home. She was divorced, had no one helping her. I think she had an 11th grade education. She was working in a factory in the western suburbs. And she had personality problems to begin with. She was schizophrenic. So, I mean, this poor lady just had a whole bowl of issues. So Maitan begins the case, and she eventually gets out of the hospital and goes through rehab for months and months and months. And at some point in time, Maitan says, there's this very talented trial lawyer in Chicago. I want him to try your case. Okay, and the lawyer's name was Rosen. And the lawyer began prosecuting the case. She was a difficult client. She couldn't keep the truth. She was sick. She couldn't tell the truth. And I know this because I had to prep her as a witness in the disciplinary hearing. She had tried to kill herself a number of times. She tried to kill herself a couple times before our disciplinary hearing. It was very difficult dealing with her. When we at the disciplinary commission bring charges, we have to use the witnesses. You know, we have to find those clients. We have to, you know, and I can't tell you, that was a difficult client to prep because she was candor challenged. The issue was I could always step back and say there's a reason for her being candor challenged. This woman's been through the mill. And what happened was, the day of trial, and she looked like a victim, let me tell you. You put her on a stand, your heart would break when you looked at her. Scarred, just completely out of it, sad lady. And all she cared about were her little kids at home, kind of thing. The lawyer said, look, they don't want to go to trial. And this is going back in the 70s. Tell you what, if I get you $200,000, will you take it? I'll make sure after all your costs are paid, you'll have $200,000. And she goes, yeah, I'd like that $200,000. Great, so he settles the claim on her behalf. Within a couple days, the $200,000 that is received from the insurance company, he finds out that Maitan has been talking to her about investing the $200,000. The lawyer says, well, what are they talking to you about investing your settlement proceeds in? She says, well, there's a judge of the Circuit Court of Cook County who has a collector's stamp company. This is Cook County, okay? You guys understand. He's a judge in the law division, and he's a collector of stamps, a philatelist, and he owns a company where he sells stamps. Now, those of you who know judicial ethics say, how can that be? I'm not going to answer that question. He just did. And, right. so turns out that the lawyer said, well, you're going to invest that money? Then I tell you what, I'll do the investment documents for you. He never reveals that the judge is a good buddy of his. He never reveals to this person who is really sad, who really should have had a guardian over the estate dealing with this stuff, that, you know, collector stamps, it can be a little bit speculative, and that maybe the judge who owns the company shouldn't be in that business because the Judicial Ethics Code prohibits it. So it turned out that she did invest the $200,000, and lo and behold, the $200,000 disappeared. What a surprise! Mytan was disbarred by then. Rosen happened to represent him during the course of his disciplinary case. But then the focus turned on Rosen. He said, wait a minute, I never received a penny. So the Illinois Supreme Court said, but wait a minute, you had this sick and troubled client. And you drafted an investment document for her when you knew she was that troubled? Yeah, but you know what? She could have walked away from it. But she didn't walk away from it. She trusted you because you were in a position of authority and responsibility. So the Supreme Court said something novel. Yes, you didn't personally benefit, but you didn't give adequate disclosure to her. Essentially, you led her to be victimized by wolves. You're going to be disciplined, and you are not going to be allowed back into practice unless you make restitution with interest to her. So they crafted kind of a novel sort of remedy. So those are give you examples about, you know, what you typically see when the Illinois Supreme Court acts in a disciplinary context. Now let's talk about threats. You try to do the best job for your client. You really do. Once in a while, your client will file a grievance against you. Why? Many times they're troubled. They don't know. They're just desperate. I love going to speak to public defenders, okay? Especially them in felony. Especially them that aren't Cook County public defenders that don't have a union. You talk to people whose caseloads have jumped from maybe 150 felonies a year downstate to 600. We had a big problem with that with the methamphetamine scourge. And when you're a public defender and you have no union, and you basically have a caseload that's insane, and you go to the county and say, can we please have more money for the public defender budget? What do you think the response is going to be? So it's a very challenging area of practice. But when I go to speak to the public defenders and those in felony, I'll tell you, those people have been the subject of 5, 6, 7 grievances in their career. Why? Their clients, some of them truly believed that if they were any good, they wouldn't be public defenders. You know, that's the mindset. Or you've got a desperate client that files a grievance saying, I don't care, I got to try A, I've got to try B, and you know what? No hard feelings, but I got to file a complaint against you. And maybe sometimes lawyers do make mistakes or errors because they're too busy. Or maybe they do have a bad lawyer. And the Chicago Tribune did a series on those on death row. One of the first challenges of the series was to write about defense lawyers and then prosecutors. And I got a call from the Tribune when they were putting the series together, and they said, how many people on death row, how many of their attorneys have been disciplined? You would be surprised at the number of people who were in death row who had lawyers who were disbarred or suspended at some time after the representation, or were going through disciplinary proceedings during the course of the representation, or had been disciplined in the past. So I just throw that out because it is an interesting world we live in, and we deal with volume. Now, in dealing with the client that does say they're going to file a grievance, there's nothing you can do about it. And a lot of times I know lawyers will say, you know what, if you want to file a complaint, you go ahead, here's their address, they have a website, they have paralegals that can walk you through the complaint process. You can't stop them. You just have to do what you've always done, represent the client as best as you see fit and as competently as you see fit. Now let me tell you, in this horrible Lilac book, before I turn this over, I just got another minute. In this horrible Lilac book, don't blame me for the color, please. One of my associates said, don't you like this color? I said, oh, come on. I got to be serious with people. I think they're lying to me. Give them a Lilac book. These contain all the rules relating to the admission to practice, the Judicial Ethics Code, the Lawyer's Ethics Code. And I just want to point out to you what every lawyer in this state has to follow. The guidelines on page 47 of this Lilac book, you'll see there's an ethics rule. It's Rule 1.14. And I love the title of this thing, Client Under a Disability. What's that, like the client's under a tree? It's an offensive remark, I've had lawyers in your industry say, because you know what? A disability is meaningless. What happens is a client's ability to communicate with me in such a way that I can comply as a professional with his or her requests. And you'll see that this rule basically says under subsection A, if you do have a client under a disability, try to maintain as normal as possible an attorney-client relationship. And if that don't work, you can seek the appointment of a guardian. Okay, is that helpful to any lawyer in the room? This wasn't drafted by people in your industry. This was drafted by people, litigators maybe, the corporate law section of the ABA. There is pending before the Illinois Supreme Court a proposed change in the ethics rule. And I'll just mention what this rule change suggests before I turn it over to Alexander. It's in the materials on the website. New Rule 1.14 contains a rule and a series of comments. The comments are critically important. The Illinois Supreme Court, maybe in January, will consider a whole package of ethics rules amendments. We have to have some changes. Most of the big rules will remain the same. Most of them will not impact your practice. But when you look at something like this rule, hopefully it'll give you a little more guidance. The Supreme Court could adopt comments. I will tell you this, the liaison justice between the Illinois Supreme Court committee that gave the final imprimatur on these rules in the Illinois Supreme Court, her name is Justice Ann Burke. Justice Ann Burke is very interested in these issues dealing with guardianship and children and situations where clients have a diminished capacity. That's the change in the title of the rule, dealing with a client with diminished capacity. Because disability, that's meaningless. Challenge is capacity. The rule basically says this. Obviously, as you try to do, you try as much as possible to maintain a normal attorney-client relationship as reasonably possible. But when the lawyer reasonably believes the client has diminished capacity and is at a risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may, not must, but may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seek the appointment of a guardian. And in the comments, there are more explicit definitions of what, in your professional judgment, if you think the situation is so bad, you may be able to do. Such as maybe even bringing a family member aboard, or consulting with a mental health expert. There is even a provision that deals with emergency legal assistance, where a client comes in to see you and they just can't form the requisite attorney-client relationship because they don't have the capacity to do so. And you know what I told you about the aging lawyer population? Well, the baby boomer clients are getting way old. I'm advising a lot of lawyers with a lot of issues. You know what? Get to know an elder law lawyer. Because in your practice, you're going to be dealing with elderly issues. So you better be able to understand the particular needs of dealing with an older client population. This proposal talks about emergency legal assistance that a lawyer might have to engage in if the situation is bad and that there is a fear that that person is going to be victimized. So thank you. I'm going to turn it over now to the doctor, who has a pretty baby on that screen.
Sure. I'm Alexander Brown, and I'm a social worker, and I work at Metropolitan Family Services, which is a very, very large nonprofit that serves Cook and DuPage counties. And one of the reasons I love working at Metropolitan is that we have a legal aid bureau, a legal aid division, and it is just fantastic to have that resource available both to staff and to clients. And I'm also very, very pleased to be here today. One of the reasons is the number of times I've heard reference to social workers today, and it's clear that the social workers are seen as partners, And when I go to other conferences, like for psychiatrists or psychologists or other sub-professions, there's a very different feel to it when they reference social workers. So I will try to cover as much material as I can on the slides, but I know I won't get to all of it because we want to have some opportunity for questions and answers. So who are the difficult clients? They're stressed, they're scared, they're unreasonably demanding, they're emotionally unstable, they're mentally ill, they may be demented, cognitively impaired, substance abusing, angry, they're looking for revenge through the courts, and they're family and friends. Those clients that you're seeing that are your family, friends you have some personal connection with. One of the arguments that I'm making is that, and I get a lot of pushback from attorneys around this, is there's no such thing as a difficult client. That all of us, in the proper context, are difficult. People come to you in periods of tremendous crisis, tremendous stress. I have 2 doctors. I know one of the doctors loves me. I'm a great patient. The other doctor hates me. And I can acknowledge I am a difficult patient. So he would call me a difficult patient. He'd put me in that category. So that's one of my arguments, that it's very contextual. Nevertheless, there are some people who are more prone to get into situations and contexts when they become difficult. And those are the ones that go see 7, 8 attorneys in a row. What do difficult clients do? They're unreasonably demanding of the court's time and energy, calling over and over, demanding meetings, not letting you get off the phone, staying in meetings. They're showing up for unscheduled appointments. They're non-cooperative, not providing you the needed information. They're giving conflicting information, even within the same meeting. People are nodding their heads. Do you know these people? Does this sound familiar? Okay. Angry. They're frustrated. They're frustrating your efforts to provide effective representation. So what you want to do is prepare before the first meeting or call, to whatever extent you can, to use any information you may have about the client, and it may be very, very limited. Know the type of people and behaviors that impair your ability to work. We are all better at working with certain types of people than others. We all have certain sensitivities or buttons that get pushed. So knowing what yours are. There are some people who are really, really comfortable with clients that are really needy. There are others that are really comfortable with people that are demanding. And there are those of us who are not. Unappreciative. Are you the kind of attorney or paralegal or social worker that really needs people to say thank you? You need to know that they are recognizing your efforts. DV, domestic violence perpetrators and other abusers, can you just not really work well with those kinds of people? Old, young, reminiscent of family members. Over the years, certainly I've had clients that, my gosh, they just look and sound like my cousin, my brother, whoever it is, and it doesn't help the process. At the first meeting, on the first call, try to set the ground rules. How do we work? I'm your client, you're the attorney, you're the paralegal. How do we work together? Do we chat informally before starting work? How much? Are we all business? What do we call one another? Do I call you Mr., Ms.? Do you call me by my first name? There are messages about that. Do we both share personal information or just the client? And how much? Do we focus only on the legal issue at hand or identify other needs like social service needs? What happens when a non-legal need is identified? If I'm coming to you as an attorney, are you going to work on those legal issues only? And I know in this crowd, your tendency is often very appropriately to help with lots of other truly non-legal issues. And it may be by referring to an in-house social worker or simply helping on your own. But those can become gray areas for the client. So letting them know what you're going to be working on, how you're going to work with them. And the ground rules start being set from the first phone call, or even by how someone describes you. Oh, you got that attorney. Oh, you're going to Legal Assistance Foundation. They are such and such. Whatever the reputation is, that's going to give the client some information about the ground rules. When the problems start, check your own feelings and perceptions. Are your buttons being pushed that will make it hard to be effective? When there are problems starting, how much of it is me? I just cannot work with this type of person. I need a different assistance or I need to behave differently toward them. Try to empathize and understand. You all work with clients who are, again, in particularly difficult straits. They generally have multiple problems in many areas of their lives and very, very limited resources. Identify the overall goals. Obviously, to provide high-quality representation and efficient use of time, and talk about those with the client. What are our goals here? What are we trying to do? And to stay focused on the immediate objectives. If you're having a difficult meeting or phone call with a client, what is our objective right here, right now? I need you to sign this piece of paper. That's my objective today. We may have other objectives, but I need you to sign this. I need you to tell me, do I go in this direction or that direction? General steps to take to identify the specific problem behaviors and target them explicitly and openly. You know, I gotta tell you, it's becoming really difficult that you're calling so often. And I just don't have the time available to be able to respond to you in the way you really want. And that's not very judgmental. It's acknowledging that I don't have the resources. Explaining the consequences unemotionally. You know, I just got to tell you, if you're not able to answer my questions just really clearly and crisply, it's going to be harder for me to make a strong argument with the other attorney, the judge, whatever it is. So letting them know that if they don't follow some of your rules better, they're going to be the ones to suffer. And again, making the ground rules and expectations more explicit as you identify that the client may be difficult. So just generally what starts happening in a face-to-face or phone call meeting when someone starts escalating, the initial stage could be called initial escalation, one of anxiety. You want to intervene with supportive action. So what you're going to see with someone is an increase or a change in their behavior. They're going to be spending lots of non-directed energy. They're going to be pacing. They're going to be moving around, looking around, talking kind of randomly, fast, wringing their hands, muttering. They're getting more agitated. They're getting more anxious. The energy's going up. You want to intervene with support, empathy, active listening, being non-judgmental, understanding, conveying the understanding, calming voice, giving them anything that will help them calm down, a drink of water or juice. Try to address any immediate need that they may have. The next stage is something you could call secondary escalation, defensive. And there you want to intervene with more directive actions. You're going to see them beginning to lose rationality. So they're talking more angrily, they're talking faster, they're not processing so well, they're not thinking so clearly. I see smiles. That too is familiar. They may become more verbally belligerent and hostile, challenging you and your authority. They're starting to lose the ability to think logically, so they're more responsive to your posture and your proximity and tone. So they're not listening to the words as much as the music. So the attitude you convey is going to be more taken in by them. So how you're standing, how you're looking, and the tone of your voice. The interventions to stay rational. They are becoming less rational. You want to help them stay rational. Focused, clear. Don't let them know that your buttons are getting pushed. And people, when they're getting agitated, people who are emotional, people who are mentally ill, tend to have really good judgment in that one area, knowing when they're getting under your skin. And on some level, they're going after it. That's getting a response. Can't indicate that that's happening. You're going to become less supportive, more firm. You know, you need to stop shouting in my office. You cannot talk that way to me in my office. You know what? If you don't stop yelling at me on this phone, I'm going to have to hang up. I'm going to hang up. I'm hanging up. I'll talk to you soon. Later. That's really okay to do. And I think most attorneys have no problem doing that. I think this group probably has more difficulty because you're chosen to work with a certain population of clients that have so many other kinds of problems. So certainly social workers have a horrible time doing this and get horribly abused by clients. And when I talk with the social workers about, hang up, tell them nicely, and then hang up, they're like, oh no, I'd hurt their feelings. Not okay. So less supportive, more firm, firmer voice, not emotional. Setting behavioral limits with explanations. You know what? I'm going to have to ask you to leave my office. What's going to happen? However you work, in whatever office, whatever agency, if someone becomes potentially violent in your office, what happens? Imagine many of you have some kind of procedures in place. You tell the client, if you don't stop it, I'm calling the police. And they are going to come here and they're going to escort you out. Let them know what the consequences are. Answer why, give them simple options with positive consequences when possible. You know, we need to stop this meeting now, but I want to see you next Thursday at 4 o'clock. So you're giving them something to hold on to. Or would 3 o'clock be better? So you're giving them more of a sense of control. And then after, it's all over, they've calmed down, you're going to see the physical and emotional coming down, muscles loosening, emotionally drained, like that. They may be embarrassed, they may be remorseful, apologetic. They're starting to think more clearly, but it's still really easy for them to flash back up. You want to reassure them. Let's take a few deep breaths, allow them choices, get them a drink, let them know it's okay, state the consequences. You know, this was really a difficult meeting. And we need to talk about what happened. But I'm going to continue working with you. We're going to fix this. And I'll see you next Thursday at 4, or would 3 o'clock be better? I'm going to talk a little bit about personality types. I'm sure most folks are somewhat familiar with the DSM-4, which lists the actual mental disorders in this country. And personality disorders are one big category. They are enduring patterns of behaviors and feelings. They're very different from cultural norms or expectations. They're pervasive, inflexible, stable. They begin by early teenage years or early adulthood, and they lead to emotional distress or impairment in functioning. So I don't want for you to think about the personality disorders per se, but think of the characteristics, because of all the different characteristics that I'm going to run through quickly, we all have most of them at different times in our lives, in different situations. But most of us fit more often into one general group or not. There are folks whose temperaments, whose characters, tend to be a little bit on the anxious side, a little bit on the paranoid side, a little bit on the aggressive side, a little bit on the narcissistic side. So think about that. Everyone exhibits some of these characteristics. And if you can sort of shorthand characterize someone, it helps. So for example, one is dependent. And dependent personality has someone who has an excessive need to be taken care of that leads to submissive, clinging behavior, fear of separation, difficulty making everyday decisions without an excessive amount of advice and reassurance, needs others to assume responsibility for most areas of their life. I have relatives like this all the time, not under certain circumstances. They feel uncomfortable or helpless when alone because of exaggerated fears of being unable to care for themselves. They urgently seek another relationship as a source of care. They're unrealistically preoccupied with fears of being left to take care of themselves. With those type of folks, some strategies are be very gentle and reassuring, supportive, encouraging. Expect them to want you to make all the decisions, which obviously you cannot do. Be aware that any suggestion or hint of suggestion you make will tend to be accepted. So something that you're saying as a suggestion to think about, they're hearing as a clear directive, you should do this. So they're going to put a lot of extra weight on any suggestion you give. So one thing to do there is they're going to have difficulty weighing the options, present the pros and cons, and give them homework. Why don't you go home, write out the pros and cons that we just talked about, and write down the options, just like we talked about, and talk about them with friends and family. Folks like this tend to have wide support networks because they're so hungry for that support. Write them down, weigh them out, prioritize them, and bring it back to me in writing. And don't answer the question, what would you do if you were in my shoes? What would you suggest to me if I were your brother or sister? Because if you answer that question, they're going to hear it as, that's what you're telling them they must do. Only suggest things that you're very clear you want the person to do. Don't let them see your frustration because they're going to feel very, very disappointed and that they've upset you. consider giving them a standing time for a phone call, because they're going to tend to be very needy and want a lot of your time and get very anxious when they can't get you. So let's talk every Monday from 12 to 12:15. You're in my book. It's there. And they'll be reassured by that. Histrionic, people who are excessive, they have excessive emotionality and attention seeking. They're uncomfortable when they're not the center of attention. Inappropriate sexually seductive or provocative behavior. They use physical appearance to draw attention to themselves. Speech that is excessively impressionistic and lacking in details. These are folks that I cannot work with. I mean, I really, for me, I have such a hard time. They go on and on and on, and they're so theatric, and they're so dramatic, and they don't say anything, and I have a really hard time working with them. And it's not just clients, colleagues. So strategies with these folks: listen very carefully and be patient, because these clients want to talk and talk and talk and never seem to get to the point. Allow the client to express and vent, because they need to be the center of attention. They need to feel important, even if it's not relevant to your discussion. Just smile, nod, think about something else. Flatter the person, but be careful about sharing personal information, because they're going to experience that as more seductive, more emotionally close than you're probably intending, and expect to be frustrated. Balance being very gentle, because they're going to feel like you're not paying enough attention or appreciating them. And after a period of allowing the expression, narrow the focus. During the work part of the meeting, okay, you know what? We're starting to run out of time. There are a few things I really need to get from you today, A, B, and C. So let's really just focus on those right now. Don't hesitate to be quite forceful and directive, because their response to that is, that's fantastic. And by the way, okay, hold that thought if we have time at the end, but I really have to get A, B, and C from you today. Before you walk out that door, I need this. And again, be cautious about making suggestions, as the person will tend to accept them. You'll have to work harder to make sure the decisions are really the client's and not yours. And again, consider giving them a standing time for regular phone call. Narcissistic, grandiose sense of self-importance, preoccupied with fantasies of unlimited success and power, believes that he or she is special and unique, can only be understood or should associate with other special people, requires excessive admiration. When you think of these character traits, you know, the personality disorders in the DSM, the disorder part is that they're so rigid, they're so fixed. The person is like this in almost every part of their lives. But if you look at these characteristics, just slices of them, you probably see yourself. Not in all of them, but at different times. And that's okay, that's a good thing. Has a sense of entitlement, is interpersonally exploitive, taking advantage of others, difficulty empathizing. Just can't quite get out of myself to understand someone else. Strategies. Give them approval and compliments. You know, a little bit goes a long way. Mention your background, experience, degrees. Here where it's a little difficult, because someone who's a little bit narcissistic, they're going to want to see you as someone really special too, because you have to be deserving of being their attorney or their social worker. Okay? But if you're too special, they're going to feel threatened. So you have to be at their level, just a little bit down, a little bit lower. So expect personal questions. They may want to know that you drive a nice car, live in a wealthy suburb, as long as it doesn't make you appear better or more successful. Flatter and compliment, but only when you can be sincere. If the narcissist makes a good point or asks a question, tell them so. They'll really respond well to that. Don't patronize, because they will flip from being flattering and charming to being angry at having been treated poorly. They'll look for signs of being a special client who gets favorable treatment, like a little extra attention from the support staff in the front in the waiting room, or not having to sit so long in the waiting room with the ordinary clients. Appearing extra excited. Oh, I'm so glad to see you. It's fantastic. That'll go a long way with these folks. Antisocial. Really quickly, a disregard for and violation of the rights of others, performing acts that are grounds for arrest, deceitful fights, reckless disregard for safety of others, failure to sustain consistent work. Strategy is pay attention to your safety. Take care of yourself. Expect the person to be either charming and engaging or somewhat scary and threatening, or alternating between the two, because they're going to try to take advantage of you, and they're going to feel comfortable trying to intimidate you. If you feel uncomfortable or intimidated, tell the person, you know, I'm going to tell you I'm not comfortable with you using words like that, and you need to not do that in my office if we're going to work together. It's gently confronting the bully, which is what these folks were when they were younger, till they developed into big time. Adopt a direct, matter-of-fact, professional stance, nothing personal, keep it all business. Very clear about expectations. If anything, minimize expectations, so they'll tend not to blame you if they don't get what they want, which are generally going to be unreasonable expectations. Confirm any information that they give you from another source. Any kind of reluctance on their part to give you information or access to other folks should throw up red flags that they're hiding something or lying. Explain that the more client limits, you know, it's up to you, but if I can't talk to this person or that person, it's just going to make it harder for me to do my job, make it more likely that it's not going to go well in court. It's your call, but what you're doing is probably going to make it less likely that we get to the goal or objective. So remember, I started saying that I really believe it's situational. There's no such thing as a difficult client. Now, I imagine that this group, most of you, many of you, are familiar with Clarence Earl Gideon. Gideon, Supreme Court, in a case in the mid-'60s, which ultimately resulted in a lot of people having jobs. Yeah. That any person accused of a crime who can't afford an attorney gets one appointed to them. So he was a prisoner in Florida in 1962, hand-wrote a letter to the Supreme Court, and he had requested, he said that his burglary conviction was unfair because he did not afford an attorney and none was provided. When he went to trial, he stood up and said to the judge, I need an attorney, I can't afford one. I can't defend myself. And the judge at the time said, too bad, you gotta do it anyway. He had requested, even demanded an attorney at trial, was denied one. Over the next 2 years, he worked very cooperatively with his attorney who was appointed to him for the Supreme Court case, never asked that he come down from Washington to meet him or give him anything but periodic updates. Gideon was very appreciative for the 2 years it took the case to get to hearing at the Supreme Court. He wrote detailed responses to all the attorney's questions, repeatedly thanked him for his assistance. He was a great client. Wonderful. Finally, the Supreme Court granted Gideon's request for a new trial and determined that all impoverished defendants have the right to an attorney. At Gideon's request, his attorney then assisted finding a local attorney for his new trial, as Gideon had started asking for from his first trial 5 years earlier. So 2 attorneys, one from the Civil Liberties Union and the other pro bono former chief assistant prosecutor of Miami, spent a July 4th weekend interviewing witnesses, visiting the alleged crime scene, interviewing family members, doing all the things they should do. And then they went to the prison to see Gideon and help him prepare for his new trial. Within a few minutes of meeting with his new attorney, Gideon fired them both. Get out. He railed at the judge when they later appeared in court. They are not my attorneys. I fired them. Get them out of here. After all these years going to the Supreme Court, I want to defend myself. So one of the attorneys later wrote a report on this for the Florida Civil Liberties Union. The title of the report was, now this is like 1967, 68, so they could get away with this. The title of the report was, How 2 Attorneys Each Traveled Over 1,200 Miles and Killed What Would Otherwise Be a Perfectly Enjoyable July 4th Weekend. Among other things in the report, they said, in the future the name Gideon will stand for the great principle that the poor are entitled to the same type of justice as those who are able to afford counsel. It is probably a good thing that it is immaterial and unimportant that Gideon is something of a nut, that his maniacal distrust and suspicion led him to the very borders of insanity. Upon the shoulders of such persons are our great rights carried. Thank you very much, and we have time for Q&A. is when you have a client come to you, presents a problem that there is no legal remedy for, that you don't think the legal system is a place where they can meet the goal or whatever they have. And you tell them that, and then they come back and say, probably angrily or frustrated, how would you feel if this happened to me? I'm reminded in grad school in Boston, one of my teachers was Sophie Freud, Sigmund Freud's granddaughter. And Sophie was well into her 80s at the time. One of the things she said is, keep in mind that as a therapist, clients come to you thinking that they're going to get their needs met. And that's not the deal. They're coming to you to have their needs addressed. That sometimes the answer is no. Sometimes you simply cannot fix it. You cannot write it. So what I would say to that client is, I would feel harmed. I would feel cheated. I would feel PO'd. You're empathizing with them. You're validating. But I'm a lawyer, and these are the tools that I have. So I don't know if anyone can fix what happened to you or eradicate it or get you to where you want to go. But I know the legal system isn't the place. So maybe this is a place. I know some people at this agency, they may be able to help you. So being as honest and blunt as you can. And you just can't expect them to say, you're right, thank you very much. But that's the best you can do. So maybe you're going to have to be the first of 8 lawyers to say that. And that's okay.
Actually, for Jean Margaret, I have, hypothetically speaking, if you have a client who comes to you and with whatever type of a legal question, they get a response that they don't like, and then they say, well, if you don't like it, if you don't do very much, I'm going to report you to the ARDC. What kind of response would they get from the ARDC if they actually, other than if after I give them your name and address and tell them how to go ahead and make a report, what kind of response would they get?
The question relates to the situation where the lawyer faced with a client who says, I'm going to file a complaint against you. And let's say they do go through with that and file a complaint. What type of review is that? How is it viewed by the ARDC? We have a staff of very good, experienced attorneys. Interestingly, a number of them somehow got their start in legal services. Most of them did, as a matter of fact. They're all very, very experienced attorneys. They're our intake staff. They're 5 lawyers. And I call them the threshers. They separate the wheat from the chaff. They have a really tough job because they're dealing with the most angry of complainants, frustrated of complainants, sick individuals, and they really try to find out what it is that this person is concerned about. We have a staff of investigators and paralegals. If we can't understand what they're saying, because a lot of people have extremely limited communication abilities. If we look at this thing, we say, what are they? We can't just make hide or hair of this. Reach out, see what they're doing, and what they're trying to say. Much of the time, if it appears there's absolutely no violation of the rules, that's the end of it. And for many of you, you've probably seen that. If you have been the subject of a grievance, we'll look at it, we'll send to the person who files the grievance a letter saying, we've reviewed this, we're not going to take any reason or action, and here's the reasons why. About 20 years ago, the Supreme Court put lay people on our board of governors, the commission. One of the first things the board did is they said, stop sending form letters. And when you're a lawyer, you love your form letters. How dare you tell me personalized communication? But it was really the smartest thing that they ever did, because we're telling people what we think was wrong with their complaint and why. They may disagree with us, but they're not going to get a letter that doesn't say anything. So most of the time it's going to be resolved that way. If they're not resolved that way, typically the intake staff will ask the lawyer for a response, which begs the following question, dealing with these clients. Please paper yourself. Keep a record. You You got to keep a record. Because you're not going to remember all the nuances in a year, or 2 years, or 3 years. It doesn't have to be elaborate, but enough to say, you know, this client was very anxious at the time, threatened this, threatened that. Just a little note for yourself to refresh your recollection if you ever have to pull your file. If you are ever called upon to file a grievance with us, I tell people all the time, don't respond to it right away. You know, put it down for a day or two, because you're initially going to be so angry and upset, and that won't help you and that won't help us. And most of the time, it's going to be clear, the lawyer did absolutely nothing wrong. A lot of times it's miscommunication. You could be the best lawyer in the world, it's a communication issue. 69% of our complaints against lawyers allege either neglect or failure to communicate. And the neglect aspect is I don't know what's going on with my matter. So, although we are in theory great communicators, sometimes we screw up in that regard. Sometimes clients are lousy hearers. There's such a word. You know, so bottom line here is don't respond right away. Don't even send anything to us unless you have another colleague look at it. Because you know, it's your license, and you take it very seriously. And it might be the person looks at it and says, well, now that you described your client as a pederast who did the following bad things, what about the complaint that you didn't respond to this letter? Oh, that's what they're really looking at. So always have another pair of eyeballs look at something and tell you if it's right or wrong. And most of the time, things are going to be dismissed right at the letter writing. You know, if you're working for an office that has insurance issues, you have to be careful that you follow policy, because that could be claims made for purposes of your malpractice policies. I just throw that out. Follow whatever your protocols if you're fortunate enough to be in an office. Also, if you are the subject of any sort of grievance, even one that we send you a letter saying we're not going to do anything, never throw that piece of paper away, ever, ever, ever. Why is that? Because after an investigation is closed in our office, the thousands that are closed annually, after 3 years, everything's expunged. A hard copy, computer record, we don't know who has filed a complaint in the past. And you know your clients, some of them, they'll come back. They'll come back 3 years, 4 years, 5 years. Never destroy any correspondence for us. Because I've had a lot of lawyers say, you know what, she filed this 4 years ago. Here was the same complaint. Here was the response. You concluded it. Here's the letter. And we say, thank you, and it's gone. But we're not going to know. Also that you should be aware of, we are governed by a rule of confidentiality. We've got a website. No one knows who's lodged a grievance against a lawyer. The Supreme Court doesn't believe in publicizing disciplinary matters unless they've gotten to a serious stage of our proceeding. They've gone through a probable cause phase. So the fact that that public defender has 5 or 6 grievances, no one's going to know about it unless that public defender chooses to make it public. Because that's not our, you know, we're governed by confidentiality. However, we will tell you this, that in the event that we ever receive a threat against a lawyer, and we perceive that threat as being more than just, you know, I'm going to sue you. I mean, if there's a subtext that says, uh-oh, we're going to contact that lawyer and say, look, you got to know, someone made the following remark about you. And in this day and age, it would be like, I'm going to get that person. You know, that person's going to disappear. Oh, we better let them know. We have no vested interest in keeping that information from lawyers. And a lot of times, you know what? I mean, it doesn't happen all that often, but it happens. And you'd be surprised how many lawyers go, oh yeah, that's him. He does it all the time. But thanks for letting me know. You know, it's not dangerous, but thanks. And we're like panic-stricken. We have a protocol when we're threatened that we have to follow. Or if we perceive there to be a threat against the lawyer, we have to memorialize and follow the protocol. We don't want to make a mess up. We don't want anyone getting hurt. Some of the people we deal with are quite capable of hurting them.
We talked a lot about what I consider to be kind of a more aggressive category of difficult client, but I'm a family law lawyer with the foundation, and we deal with a lot of times we get into domestic violence, and some from sort of the other end of the individual client, being depressed, being non-responsive, maybe falling a little bit into the category of not being able to make a decision. I wonder if you have any suggestions for dealing with really depressed, maybe even PTSD sufferers in your practice.
So the question has to do with
with those difficult clients who, by virtue of their depression, domestic violence experience, trauma experience, tend to be less able to make decisions, perhaps more passive, frustrating in that way. I think those folks need as much emotional support as you have time to give them, and assistance in getting them into treatment, and then to partner with whoever's treating them, whatever agency or counselors or therapists are available to do that, when you can do that. I think those folks just need a lot more support than the average client. And that's I think in some ways probably more difficult for you because they take so much more time.
I actually have a comment. My comment is that I use your strategy once with development with a client. She's being very concerned. Maybe now, which actually a lot of hands against me, but it was discussed. But I work at the district court. We run this self-help court, and I would say that more than 60% of people that we don't have a screening process. We see everybody our mental health or our other behavior. Some of the things may not say I think it's about ages. And I guess because of our position being self-help as the contact representative on the merits of the extent, what outpatient do we have to dissuade them, discourage them from pursuing these ridiculous claims? I always feel like I have enough agents who say, really don't want to do this, but at the same time, we have 3 marshal funds in our office with some of our clients who are regulation, and I'll also be this officer. So I'm curious as to how much you
Real good question. Dealing with someone in public service, working for a court, working a self-help desk, where a lot of anxious, sometimes violent people want to file specious, defamatory, frivolous, mean-spirited actions. And how far do you go in dissuading? And you don't have an attorney-client relationship with those individuals. You probably do it right through the experience that you've acquired on the job, that sometimes you can say, I've seen this before and I've seen that before, but you got to be careful. If they're going to file the frivolous action, oh well, the court system should be able to accommodate that. You make it available. You don't want to get into a position where those people might think that you're giving them legal advice. They might think that they are giving you sufficient information without anyone listening, such an attorney-client relationship is created. That's what you want to do. You want to avoid that sort of scenario. And I'm sure you do a great job. We see a lot of those people, they sometimes file their complaints thinking we're the court system, and we get sued a lot, and it's because we're named in the complaint, but we're not in the text of the complaint. So there's a lot of sadness out there. People they think that they're getting some redress from the courts. Oh well, but you just want to make sure no attorney-client relationship can be suggested after the fact, and keep doing what you're doing.
If I could just add to that, clients, potential clients, in whatever the arena you're working in, are coming to you in part for the truth. They're asking for your honest, sincere opinion and advice. It's been very interesting to become more familiar with the rules that you all live under, and the perception of ARDC is really fascinating to me. He seems like a nice guy. And I've been sitting up here, but to me it seems like as long as you're following your rules and documenting things, a client contacting ARDC should be okay. What's at risk is really you're going to get a letter saying you didn't do anything wrong. And that's a good thing. Unless there's another side to you.
We try to literally, we have 6,000 grievances, you take them one-on-one. We realize there are people in certain industries, that Funk described as that you have more significant challenges than some people who may, for example, represent ExxonMobil.
I just have a question about one in particular for
Alexander.
Talking to somebody who might be a hoarder about the fact that they're a hoarder, or somebody who suffers from mental illness, and it's been clear that there's something going on, and you're representing them, and I want to say, you know, it really is that I can't walk into your home because it's not in your room. And that's essential to you maintaining your housing, and the cost is addressed, but kind of attempts to connect people with social services are not necessarily working, and you're kind of sitting here trying to figure out how to appropriately address that issue, or at least have a conversation about it.
So the question is regarding hoarding behavior, those folks who just have so much stuff in their house that either it feels unsafe for you to go in there, or they're going to be evicted or face some other kind of legal problems because of how much stuff they have. It's a fascinating area. What I can tell you is the vast majority of people who are hoarders do have a mental illness, and the various interventions don't work. So you want to discuss it, tell them your opinion, don't expect it to change. I've been involved in a slew of hoarding cases, and I've never seen one get cleaned up other than by force. So it's an area that the industry, the field, simply has not figured out how to treat these folks very effectively. The other piece of your question is, I think, you know, what if I go into a home and I just don't feel comfortable here, I don't feel safe here?
No, I just, you know, I have a particular client where I need to talk about the conditions in her home, and when we do, you know, she is seeing it completely different than I do.
Yeah, so-
What her sight sees and my sight sees are very different, and I don't want to either be offensive or also make her feel like I can't come to her.
So I don't think you have to worry about offending someone, because their level of denial about hoarding is so extreme that, and you're probably not the first person to mention it unless they really keep people outside their door. My suggestion would be, don't waste too much of your time talking about it, but spend a lot of time trying to get a referral to the local health department, the local social service agency. I'm from Evanston. You know what happened in Evanston last Halloween? A hoarder, a house that was just full of stuff, plus 3 dead bodies. I had been there once since the 70s, and this woman had never let anyone in her house. But hoarding is something that we just have not figured out an effective way of treating. It just doesn't get better other than by force in the vast majority of cases.
I think we have time for one more question.
This is for Dr. Brown. I was just wondering, you did talk a little bit about body language. You also talked about other just strategies with language. I'm wondering if you have, I feel mostly with my clients over the phone. I'm sure a lot of people have a lot of phone contact. I'm wondering how when you have a client that really responds well to body language, or even I'm better with eye contact and things like that. How, I don't know if you have any different strategies from talking to someone on the phone with tone or different types of stuff or language.
If you're doing the majority of your contact with clients over the phone, you're just very, very limited. Take the tools you have available, and oftentimes people on the phone feel even more comfortable being rude or intrusive, that if they have to look you in the eye, they tend to be on better behavior. Listening to their tone and matching it, listening to any background noises to get some sense of what the environment is that they're in, and being conscious of your tones when you are to get quieter and more supportive and more directive, more flipped.
Well, I want to thank our presenters today, and thank you all for coming.